Thank you very much indeed. It's a very generous introduction, and I'm extremely privileged to be here this evening to talk to you about a topic which I have been allowed to select. I do so with some trepidation, which is intelligence sharing and human rights abuses. I say I do so with some trepidation, and that's simply because I think anyone who comes to Northern Ireland to talk about intelligence sharing and human rights abuses will do so with trepidation, particularly when I do not intend in this lecture to talk about the Northern Ireland situation, Northern Irish situation. My focus is going to be on the global war on terror, as it has been called, and the intelligence sharing issues that have arisen in relation to and as a consequence of the global war on terror. And really issues that have been at the forefront of a number of cases in the English court, some of which I have been involved in, and I want to highlight a number of the ways that those issues have arisen and that the ways in which those issues have been dealt with in English courts and in other forms of accountability procedures. I want to do three things. First of all, I want to persuade you that there is an issue here and that it is a very serious human rights issue. This is not the sort of human rights issue I will suggest, the sort of unconvincing human rights issue that human rights lawyers see popping up all over the place. We all know that since the Human Rights Act, there have been human rights cases in areas as diverse as tax law and property law and all sorts of other unexpected places. But I'm going to suggest that human rights are absolutely at the heart of intelligence sharing. Secondly, I want to, as I've already suggested briefly, indicate ways that the issue has emerged in the course of proceedings in the UK since 2001, and the problems and the limitations in grappling with those issues and in subjecting the intelligence services who have been sharing intelligence with other agencies in other countries to the rule of law. And there is a real rule of law and accountability issue here, and it is an issue that I call the Teflon problem, because there is a real problem, difficulty, in the rule of law attaching to this issue and in holding those responsible and those engaged in the practice of intelligence sharing, which is, of course, perfectly legitimate practice, to the rule of law. And thirdly, I want to reflect back on those problems. I don't claim to have any solutions. The problems in this area are potentially intractable, but I do want to look forward and to make some suggestions about constructive improvements and where areas where improvements need to be made. So, first of all, the issue. There is a real human rights issue in the context of intelligence sharing. What is that issue? Well, there are no more pressing human rights issues than those relating to torture. And torture is the principal issue in the context of intelligence sharing. There are other issues, such as kidnapping and arbitrary detention, but torture is really at the heart of it. It's not immediately obvious why torture would be at the heart of it, but I will explain shortly why that is. Now, issues on torture arise in the law normally in three different contexts. Firstly, and most obviously, they arise where public officials are engaged in the practice of torture. Now, that we had hoped was no longer an issue in the United Kingdom. In 1972, the United Kingdom government gave an undertaking to Parliament and to the European Court of Human Rights that the so-called 5 techniques that had been employed in Northern Ireland would no longer be used again. we have subsequently and fairly recently discovered that in fact they have been so used, and the recent Bahamusa inquiry into the practices in Iraq has documented that. But we hope that that problem is not widespread. We hope that that is a localized problem, and we hope that it's not an issue that is going to trouble us in the future. The second area where torture issues arise is in the case of refoulement. And what I mean by refoulement is where individuals are returned to other countries where they face a risk of torture. And there is a great body of learning in this area of the law, and it is perfectly well established that if the British government wishes to return somebody to another country where they face a real risk of torture, they cannot do so, no matter how pressing the interests of the state, including national security interests, in doing so. But that is not an issue that I want to talk about today. The third issue comes closest to the issues I want to talk about today, and that issue arises where the government of this country, in one of its manifestations, receives intelligence from another country or information from another country which has been obtained through torture. Now, there has been a case which went all the way to the House of Lords on what should happen in these circumstances. And the House of Lords decided unanimously that the courts would not countenance any reliance on such information, and any information that had been obtained by torture could not be relied on in any legal proceedings. And in the course of that judgment, their lordships made very powerful statements about the abhorrence that the common law, never mind human rights law, but the common law takes towards torture, and the degrading effect of torture and all those who come into contact with it. But that issue, although it comes close to the issue I want to talk about, is not quite the same, because that is an issue about where the government receives information that has been obtained by torture. The issue I want to talk about is a different one, but it's related, and it's where information that is provided by the government of this country is given to another country which practices torture, and the contribution that providing that information can make to that torture, or for that matter, kidnapping or other human rights abuses. This is a major issue. It's not a theoretical issue. I will explain that it has arisen in many cases. And let me just explain where the origin of this issue really comes from. I'm not saying the issue is solely related to the war on terrorism, but that is undoubtedly the reason why this issue has become much more prevalent. Security Council Resolution 1269, this was before September the 11th. This recognised the need for states to exchange intelligence information, but it was not a mandatory obligation. And it was only after September the 11th, Resolution 1373, that the UN Security Council resolution did two things. First of all, it made it a mandatory obligation to exchange intelligence information, and secondly, it impressed upon states the urgency and the need to do so as openly as possible. It described, the way it was termed in the resolution is, as I've got it up here, that states must find ways of intensifying and accelerating the exchange of operational information, especially regarding the actions or movements of terrorist persons or networks. So now let me try and bring this to life slightly with some concrete examples. Three examples I want to give you. The first example is the case of Bishr al-Rawi and Jamil al-Banna. Bishr al-Rawi and Jamil al-Banna lived in London. In 2001, 2002, they were visited on a number of occasions by the British intelligence services. They were associates of Abu Qatada, who you will all have heard of. They decided, with others, to go to the Gambia to assist in a business project, which subsequently accepted was a legitimate business project. And on one of their visits to Mr. al-Rawi and Mr. al-Banna, the men volunteered the information that they were going and provided information about their travel plans. What then happens? Well, this is an extract from a telegram that was sent by MI5 to the CIA, informing the CIA about these travel plans. It described the men as Islamic extremists, described them as close associates of Abu Qatada, described Jamil al-Banna as a former financier of Abu Qatada. The first two telegrams had this caveat. This information is for research and analysis purposes only and may not be used as a basis for overt, covert, or executive action. The final telegram that was sent, which actually had the flight details of the men, omitted the final line of that caveat. The men arrived in the Gambia, they were arrested, they were detained at the behest of the CIA. They were subsequently taken to Afghanistan, where they spent time in the notorious dark prison, which is was a terrible dungeon, which is pitch black, with constant excruciating noise. People were chained to the walls. And subsequently to Bagram Air Base, where we all know what went on there, and then to Guantanamo Bay, where they languished for many years. All as a direct consequence of these telegrams. Second example. Topical example, this relates to a case that's going through the English courts at the moment. Mr. Belhaj, who is currently a senior member of the Libyan government, he was formerly a member of the independent Libyan fighting group, said a senior member, I've no idea, but was arrested, or rather detained in China by the Americans and taken to Libya with his heavily pregnant wife, where he was subject to a terrible ordeal of torture and remained until the Libyan uprising. This is an extract from one of the documents that was found in the filing cabinet of the Libyan security services when the uprising, following the uprising. And it's a memo from British MI6 to the Libyan Secret Service at the time. And the substance of the memo, we put an extract here, is that the intelligence had been provided by the British that led to the apprehension of the two individuals, and this rather chilling wording was included in the memo. Now, as I say, this is currently the action subject to legal action in the UK, and a preliminary issue in this case, which I'll mention a bit later on, was heard only, I think, the week before last, because the British security services are being sued for complicity in the rendition and torture of these individuals. The third example, I don't have a slide for, but the third example is the best known of the three. It's Mr. Binyam Mohammed. He was detained and taken detained in Pakistan and subsequently taken to Morocco by the CIA, where he was subject to really appalling torture, and then subsequently to Guantanamo Bay. Now, it's been established that the British security services visited him in Pakistan, interviewed him, and subsequently sent information and questions to the CIA whilst he was in Morocco. These examples demonstrate, I suggest, that providing information, if it wasn't obvious, it should be from these examples, to foreign countries who practice torture and arbitrary detention is extremely dangerous. And it can cause people who would otherwise not have been to be subjected to the most appalling human rights abuses. How have these issues, I'll jump that one, how have these issues arisen in the courts? Well, I should make clear that the UN Security Council Resolution 1373, this is the October 2011 resolution, did make clear that the exchange of information must be in accordance both with international and domestic law. Well then, isn't it possible for the security services to be the subject of accountability, subjected to due process, subject to legal scrutiny? Well, I've identified a number of potential ways that they could be subject to such accountability and scrutiny. And I'm going to, if I may, quite quickly run through each of them. First of all, there's international human rights law. There's no doubt both that torture is prohibited by international human rights law. It is what's called an erga omnes obligation not to torture people. That is to say, a fundamental obligation which is binding on all states, irrespective of treaty law. But it is also made clear in the UN Convention Against Torture, and the Convention also makes clear that complicity or participation in torture is also prohibited. And there is also a principle, which is also customary in international law, that aiding or assisting another state in committing a grave human rights violation is itself a violation of international law. But there's a problem with international law. International law is not enforceable. The only way that international law is enforced is either where the UK law has actually enacted or given effect to international law, or if a complaint is made by one state against another state. So international human rights law is very tough in theory, but very weak in practice. But, I can hear you say, don't we have the Human Rights Act? Doesn't that give effect to these principles in domestic law? The Human Rights Act gives effect to the European Convention on Human Rights. The European Convention on Human Rights is an international treaty, includes a prohibition on torture. But there is one great problem with the Human Rights Act in this particular context, and it is this. The European Convention on Human Rights is territorially limited. It has a defined jurisdiction. And unless a victim of a human rights violation is either in the United Kingdom or is in the custody and control of an officer of the United Kingdom, or, for example, on a military base that is run by the United Kingdom, then they are outside the jurisdiction of the European Convention on Human Rights, and it has been held, therefore, also fall outside the protections of the Human Rights Act. So, for example, of the three examples that I've given, concrete examples of where intelligence sharing has, it appears, had grave effects on individuals' human rights, it is only possibly Mr. Al-Rawi and Mr. Banna who could claim any protection from the European Convention, from the Human Rights Act and the European Convention on Human Rights, because at least when they began their journey, they were in the United Kingdom. But from that point onwards, the protection of the Human Rights Act came to an end. Tort law, private law. Surely there are private law causes of action here. It's a picture of Albert Venn Dicey, the most eminent constitutional lawyer of all, whose principle of the rule of law, which is after all what we're considering here, was premised on the concept and idea that everybody, whether they were the Prime Minister or whether they were a collector of taxes, as he put it, was subjected to the ordinary private law of the land. But there are problems with tort law in this context. Firstly, the law is very uncertain. There's very little law on complicity torts, which is what we're talking about. That is, it's not suggested that the British authorities tortured in any of my examples, but it is suggested, and it has been found in at least one of the examples, that the British authorities were complicit in that torture. Assistance does not itself constitute a tort. There must be a procuring or a joint tortfeasance in order to constitute a tort. It's an area of law which is really very untested, and the principles are vague and ill-defined. But there are more problems. Firstly, there's a problem of foreign law. After all, don't most of these acts occur in other countries? The answer to that is yes. Almost certainly in these cases, we won't be applying English law. We'll be applying the law of Morocco, or the law of Pakistan, or the law of another country. Now, that can be done in the English courts. But of course, there are issues as to what that other law actually is. It's less of a problem with torture, because most laws, thankfully, do outlaw torture, at least formally. But, for example, the law on executive detention varies considerably from country to country. Act of state, what do I mean by that? Well, there is a defence to a claim in tort, which is that this was an act of the state. It has its origin in colonial cases brought by people who claimed that the British government, the British Crown, had assumed power over certain land, taken property, demolished property, that sort of thing. And it said, no, these are acts of state. But the act of state doctrine still lies around in the law reports. And the Libyan example that I gave you is one of my second example. And I said, do you remember, that it's going through the courts and that there was a hearing 2 weeks ago. Well, that hearing was on this issue. The British government has said that if the British government was involved in the apprehension and rendition of the two claimants, then it was an act of state, and no claim can be brought in the British courts. And that issue was argued before Mr. Justice Simon, and I suspect it will certainly go to the Court of Appeal, and it wouldn't surprise me if that's an issue that goes all the way to the Supreme Court. Public interest immunity. If any documents would be too sensitive to be disclosed, the government can claim that they shouldn't be disclosed, they should be withheld on grounds of public interest immunity. Now, that's a particular problem here, because what are the documents that need to be disclosed in order to prove complicity with a foreign state? They're documents about the conduct of the foreign state. They might be telegrams that have been sent by a foreign state, for example, which say, we have this person in detention, or this person has been treated in this way. Now, those are documents which the British government says can't be disclosed because of the confidentiality of those documents to the foreign state. It's obviously a massive issue in the Guantanamo Bay claims, which were brought by Binyam Mohammed and Bishop al-Rawi and al-Banna, all brought tort claims against the British government. And the British government refused to disclose lots of documents on this basis. And on one view at least, it's very difficult to prove these cases if you can't get access to those documents. And obviously, if a foreign government is torturing people, they are very reluctant to allow the British government to provide those documents in the course of legal proceedings in this country. Settlement is a problem. Cases can be bought off. Now, I made this point to someone the other day, an academic who works in this area, and they said, well, it takes two to tango. It's all very well to say, well, cases can be bought off. but the other person has to agree to withdraw their case. Well, yes and no. There are real penalties under the procedural rules for people who continue with cases after a generous offer has been made. And many cases are funded by what is now the Legal Aid Agency. And it's not going to be very easy to justify to the Legal Aid Agency continuing with the case if a generous offer to settle has been made. There is an exception, though. This is the Belhaj case, which I mentioned, which is my second example, the Act of State case. Mr. Belhaj said he's not interested in money. He said he will settle for £1 and an apology. If the British government provide £1 and an apology, he'll settle the case. But unless that apology is forthcoming, he's not prepared to settle the case. That, I have to say, is an exceptional example. And Mr. Belhaj, as I understand it, his lawyers are acting on a conditional fee arrangement. So it's not a legally aided case, it's a case in which the lawyers are acting on no win, no fee basis. So there are some cases where settlement is perhaps rather more difficult than others. I mentioned the Guantanamo Bay litigation. This was a massively important piece of litigation, led to a major legislative reform. It was brought by about 12 individuals who had been taken to Guantanamo Bay, who alleged that the British had been involved in one way or another, different ways in each case, including Mr. Reilly, Mr. Banna, Binyam Mohammed. There was some disclosure, but the case got bogged down because there's a vast amount of disclosure and documentation, and it was going to take years and years to resolve. There was a mediated settlement with the government, which led to the withdrawal of the claims, but none of the allegations were withdrawn, and no admissions were made by the government. Subsequently, the government has suggested that it had a good defence to the case, denied that it has any liability, and has said that it was prohibited from being able to defend the case by public interest immunity, which I've mentioned before. It says, look, we were unable to put all the documents before the court that we would have wanted to put before the court because the Americans would not have allowed us to put those documents before the courts, and therefore we were unable to defend ourselves. But we had a good defence. It led to two things. First of all, the Consolidated Guidance. This is a policy which the government has promulgated which relates to exchange of intelligence. It's a very important document, and I think it's generally a very good document. And it applies to security and intelligence services, and it applies to the military. But there is a real issue about how it is enforced, and that is one of the things we're looking at. It's all very well to have a document, but how do you actually hold the services and the military accountable to it? Secondly, it only applies where an individual is already in detention. So if an individual is in detention in a foreign state, and the British are liaising with that state, or if they've procured the detention of that individual in that state, the guidance applies. But it doesn't apply, for example, in the case of Mr. Reilly and Mr. Banna, because the British government would say, well, we didn't procure their detention, so it wouldn't have applied in their case, at least until they were detained. Second thing is this litigation led to what's known as Justice and Security Act, 2013. This came into effect a few months ago. This is a major legislative reform. You may have seen it's been extremely controversial. I won't go into details on it, but we might want to talk a bit about it in questions later. But the essence of the Justice and Security Act is that it allows the government to trigger, with the consent of the court, a closed material procedure. What that is a procedure that allows the government case to be advanced behind closed doors. Not just behind closed doors, but to the other party excluded. So the claims, for example, that were brought in the Guantanamo Bay litigation, the claimants would have been able to advance their case in open court, but then they would have been excluded from the courtroom whilst the government advanced its case. Sorry, my phone keeps buzzing. I've got it on so I keep an eye on the time, but I'm not quite sure why it keeps buzzing at me. Anyway, forgive me. That's the Justice and Security Act and the Consolidated Guidance. I can move a bit more quickly through the other potential mechanisms of accountability. Criminal law. Well, the criminal law obviously applies to the actions of the intelligence services. I've got up there the provision that relates to torture. Complicity in torture it is included, not least because of the Aiders and Abettors Act. But there are other provisions. Kidnapping is a criminal offence, for example. Aiding, abetting kidnapping is a criminal offence. But so far, the criminal law has not, as it were, contributed a great deal, at least openly, to this process. There have been some serious and prolonged criminal investigations, but they haven't resulted in any charges, and very little information has been disclosed from those investigations. I've got here the joint statement by the Director of Public Prosecutions and the Metropolitan Police Service following the investigation into the incident surrounding Binyam Mohammed. And what this statement says, says the investigation is now complete. Having reviewed the evidence carefully, the CPS has concluded there is sufficient evidence to show that A, members of the security services provided information to the US authorities about Mr. Mohammed and supplied questions for the US authorities to put to Mr. Mohammed while he was being detained between 2002 and 2004, including at times when Mr. Mohammed's precise whereabouts was not known to them. And B, that Mr. Mohammed was held in Morocco for at least some time between July 2002 and early 2004. However, the CPS has also concluded that there is insufficient evidence to prove to the standard required in a criminal court that any identifiable individual provided information to the US authorities or supplied questions to the US authorities or was party to doing so at a time when he or she knew or ought to have known that there was a real or serious risk that Mr. Mohammed would be exposed to torture. Now, of course, maybe because there was no evidence at all, or that there was no evidence that would satisfy the criminal standard. But 2 points do merit mention here. First of all, it is the fact that in a criminal case you have to prove claims against individuals, when of course it's quite possible in some of these cases that there has been an institutional breakdown where an institution has been aware of risks, but individuals maybe that provide information are not fully appraised of those. In those circumstances, the criminal law has very little to say. Secondly, there is of course a very high standard of proof which has to be met in a criminal case, and one of the difficulties here again is public interest immunity, because if a public interest immunity claim is made in relation to information which is relevant to a person's defence in a criminal case, the prosecution will inevitably not be pursued, because that information can't be relied upon. There are ongoing criminal investigations. There's a wider investigation relating to the Libyan allegations. But so far, that has been the sum of the outcome. The Investigatory Powers Tribunal. Now, the Investigatory Powers Tribunal is a tribunal that's been set up by Parliament to deal with complaints against the security services. There are a number of limitations to the Investigatory Powers Tribunal's jurisdictions and reasons why lawyers such as myself are very reluctant to go there. One is that closed material procedure, as I've described it, has been used. So what happens is the complaint is advanced in open, but the government's defence remains secret. If a complaint is dismissed, then all one is entitled to is a statement saying the complaint is dismissed. If the complaint is upheld, you may get a summary of the reasons for upholding the complaint. you may not. But that is the sum of it. Also, I've put up here the number of claims brought and the success rate. You can see that the success rate is not very high. Now, I should make clear that there are some obvious reasons for that. I suspect that the IPT is fairly inundated with claims by people who believe they're being followed around by the security services and who aren't being. But nonetheless, it doesn't have a particularly high success rate. And another problem with the IPT is that legal aid is not available if you go there. Now, there was a case that was handed down today by the Court of Appeal, which relates to, this is the case about the policemen who were having sexual relations with the people that they were providing covert intelligence on. And the Court of Appeal handed down judgment in that today, and one of the main points of the judgment was whether or not the claims had to await the outcome of the IPT. And the court was quite critical, I think, of the IPT jurisdiction, or at least acknowledged the real limitations in it, and didn't regard it as an acceptable substitute for a tort claim at common law. What about judicial review? After all, judicial review is the principal way that the rule of law is enforced in the United Kingdom, or at least it's been developed precisely to ensure that public authorities adhere to the law, including the Consolidated Guidance in this case. But judicial review in this context has had almost nothing to say. First of all, the cases that have been brought have been met with a response which has been upheld by the courts that you first have to go to the Investigatory Powers Tribunal. It's an alternative remedy. And secondly, even if you get over that hurdle, you don't get disclosure in a judicial review case. And now we have the Justice and Security Act 2003, so even if you do get into judicial review proceedings, you will be having a secret hearing. So we must look further afield for ways that the rule of law is engaged in this context. And it's strange that actually the cases that have looked into this issue, the legal cases that have looked into this issue in most detail and where there's been most disclosure are abuse of process cases. These are cases where people have been prosecuted and convicted, in some cases, of criminal offences relating to terrorism, but have alleged that the security services have been complicit in human rights violations which taint the criminal proceedings to such an extent that it's an abusive process for them to be continued. And the way it's been put in the leading case of Bennett is that the courts accept these arguments in extreme cases because of the rule of law and because the courts oversee executive action and refuse to countenance behaviour that threatens basic human rights. And the case of Mullen, which is of course about Northern Irish terrorism, is the best example of this, and the case where there was in fact most open discussion of the complicity of the SIS, MI6, with a foreign intelligence service in a human rights violation. And the reason why there was so much discussion of this was because by the time the case arose, Mr. Mullen was already convicted of a very serious terrorist offence and was raising abusive process on appeal. And obviously, the British government was desperate to uphold the conviction and therefore disclosed a lot of material about the involvement of MI6 in his apprehension in Zimbabwe, but nonetheless failed. The court said no, Mr. Mullen had been apprehended and brought unlawfully to the United Kingdom to be prosecuted and face trial, and that was a serious human rights violation that tainted the conviction sufficiently. The case arose in the modern context of intelligence sharing post 9/11 in Ahmed and Ahmed. Is there something here on the okay. That's all right. Thank you. Thanks very much. In this case, the defendants argued that the prosecution was tainted because they'd been tortured in Pakistan by the Pakistani intelligence services. They alleged that the British intelligence services had been complicit, had provided intelligence to the Pakistani intelligence services, and that this had had an impact on their investigation and trial. And the court rejected this argument and took, I think, a slightly more restricted view of abuse of process and the court's willingness to countenance that a prosecution should be stayed on the grounds of abuse of process. It says there has to be a direct impact on the trial or the criminal investigation. And it said, I think, somewhat in a contrary vein to Bennett, that the jurisdiction of abuse of process does not exist to police intelligence services. So there had, at least in that case, been some quite detailed consideration in open court of the involvement of the intelligence services with the Pakistani intelligence services, but nonetheless, the jurisdiction was, as it were, restricted. The issue has also arisen in the context of TPIMs and control orders, and it was alleged in that context that two individuals who had been taken from Somaliland, brought to the UK, placed under a control order, that control order was tainted as an abuse of process because the security services had been involved in that operation. And in this case, there was a closed material procedure because this was a control order case, and in all control order cases, you have a closed material procedure. So most of the case is conducted in secret. And what's interesting about this case is that the High Court considered this issue, rejected the allegation of abuse of process, but it didn't provide any reasons at all as for why it was rejecting it. Because it said it would have been contrary to the public interest, contrary to national security, if it said anything about the government's response to the allegations of abuse of process, and therefore it was precluded from saying anything at all. And look, Mr. Justice Lloyd-Jones said this, simply that the position of the Secretary of State in these proceedings is that they neither confirm nor deny their involvement in the deportation, detention, arrest of the two individuals. And he said, with considerable reluctance, I've come to the conclusion that I cannot address these matters in my open judgment. And of course, the closed judgment is not made available to the individuals or their lawyers, and it's not made public. Bizarrely, I've got two more. I want to go to 9, so I've only got 2 more. And this has been the most important, most significant legal means for holding the government to account in the context of intelligence sharing. And I say it's bizarre, because this is not a legal remedy that anyone had really appreciated had any significance in this context. It's called Norwich Pharmacal, and basically it's an application for disclosure of documents. And it originates in the context of intellectual property. And it originates in the idea that if somebody is mixed up in a copyright infringement or an intellectual property infringement, they have to disclose the evidence against the primary wrongdoer to enable justice to be done. And Binyam Mohammed brought this claim asking for disclosure of documents that he was going to use in his criminal defense in America, in the British High Court. And there is an extensive judgment of the Divisional Court setting out findings in relation to the involvement of the security services with the Pakistani security services, the American security services, and in relation to Binyam Mohammed's detention in Morocco. Very important, significant judgment, which really opened up this issue in a way that no other proceedings have been able to do. Of course, it went to the Court of Appeal. In the Court of Appeal, the court ruled that certain further findings that had been included by the Divisional Court in its judgment but redacted should be made public about the mistreatment of Mr. Mohammed in Pakistan and about the knowledge of the intelligence services of that mistreatment. And the Master of the Rolls made these important comments. He pointed to the fact that the security services have made clear in an investigation into this very issue to the Intelligence and Security Committee that they adhered to a culture that respects human rights. But he went on to say, but in this case, it does not seem to have been true. So we have findings, very important findings, in relation to complicity in human rights abuses in the context of intelligence sharing, but arising in this really unusual context of a Norwich Pharmacal action. What happened to the Norwich Pharmacal action? Well, it was abolished. It was expressly abolished in the Justice and Security Act 2003, which says that any actions for disclosure, etc., Norwich Pharmacal, shall not be permitted in the national security context in future, and indeed there is also a subsequent Court of Appeal judgment in a case called Omar, which also found that the court itself had overstretched its jurisdiction in this case, although the point had not been argued, and that the Norwich Pharmacal jurisdiction should not have been permitted in this context. Finally, the Intelligence and Security Committee. This is Sir Malcolm Rifkin, who is the chairman of the Intelligence and Security Committee. You may have seen in the news that the Intelligence Security Committee today has had, for the first time, an open session, and the three heads of the intelligence services, GCHQ, MI5, MI6, have been given open evidence today to the committee. But the committee's track record is very poor. For example, they had given a clean bill of health to the security services in the context of Mr. Mohammed's claim, and it subsequently turned out in the Norwich Pharmacal proceedings that the committee had not been provided with effectively the key documents in that case, and it obviously made them look rather silly. You may have seen the report that the Intelligence Security Committee had produced recently in relation to the allegations of use of the PRISM data from the US. It is a very short report. There is very little public information about compliance with human rights principles that is produced by the Intelligence Security Committee, but perhaps today, and the session they're having today, may indicate that they are going to take a more robust role in the future. So let me just reflect quickly on these potential rule of law mechanisms in the context of intelligence sharing. International law, not enforceable. Human Rights Act, inapplicable. Tort law, very problematic. After the Justice and Security Act, secret. Criminal law, the jury's out. It is still of unproven effectiveness, and the information that's arisen, in contrast what was said there in the statement from the Director of Public Prosecutions with the lengthy judgment in the Binyam Mohammed case on the same facts, obviously it's much, much, much shorter and less informative. The Investigatory Powers Tribunal, again, it is yet to earn its stripes. Judicial review, so far, has had no role. Abuse of process looked promising, but the courts have really resiled from having a significant role in this context. Norwich Pharmacal, the most effective means prizing the lid, prizing the lid of the tin in this area, making something stick to the Teflon frying pan. But it's been abolished. It's been abolished twice. And then the Intelligence Security Committee of Parliament. Secret and ineffective so far. Have I got 2 minutes? So, just reflecting back on these issues and suggesting a way forward. Obviously, there are real difficulties in this area. There is fundamentally a clash of human rights principles and imperatives of intelligence sharing. There's no point in shying away from that. The idea that we have to stop sharing intelligence with countries that routinely practice torture is not one that can gain any traction. We are going to have to find ways of continuing to do so. The law, however, is unclear in a number of areas. I've referred to tort law, referred to international law, criminal law. The area of complicity is one that's inherently uncertain. There is two fundamental problems, difficulties. One is the international nature of the issue. We're talking about crossing national frontiers, different legal systems, dealing with foreign governments, and the second is the issue of secrecy. And not only is this a problem in relation to, obviously, the need not to disclose information that might lead to the harm of any sources or disclosure of any operationally sensitive intelligence, but in this area we have the really intractable problem about disclosing any information that's been supplied by the people who are the principal wrongdoers. And I say I don't have any solutions, but it does seem to me that there are at least some thoughts which might lead to a more constructive rule of law protection in this area. International law seems to me that this area is calling out for some form of clear international agreement on when intelligence sharing is permitted and the limits on it, and that some guidance needs to be given as to when the imperative set out in the Security Council resolutions that we've seen, that states must share intelligence, how it's to be reconciled with the idea that they have to conform to human rights principles. Human Rights Act, not much we can do about the Human Rights Act, but if there is to be a British Bill of Rights or even a UK Bill of Rights, it would be nice if it has a wider jurisdictional reach. Tort law, seems to me, has to reject immunities, and the courts are going to have to try and find a way to make the Justice and Security Act, with its secrecy provisions, a mechanism for not only scrutinising the security services, but also providing some sort of meaningful information about compliance with the governing norms in this area. So there are some, there's not tinkering. It seems to me there are some really significant improvements that can be made, but it doesn't seem to me that there is any clear and obvious solution to how one makes intelligence sharing subject to accountability mechanisms that can give us confidence that the rule of law is being adhered to in this context. And it is a real concern and a real challenge for the rule of law, because as I hope I have demonstrated, these are not theoretical issues. These are real practical issues that have a direct effect on the lives of real people.